the amendment bill involving fronting and of course addressing that big problem here in South Africa. That's been approved by Parliament. Final signature by the President is expected to be done by the end of October, bringing this into law. As with any legislation, it still needs to be tested in the court of law. So let's take a look at the ramifications. We've got Keith Liebenstein, CEO of EconoBE, joining us in studio. Thanks for joining us today, Keith.
Good evening.
So ultimately, this is new legislation here in South Africa, and what we're looking at it from when it comes to addressing the fronting practice in South Africa is ultimately criminalizing this. So tell us about the nuances and the changes in the legislation that are going to affect us on the fronting front.
Well, Samantha,
fronting front, didn't mean to say that, but yeah, on the fronting issue.
Yeah, Samantha, this legislation, of course, is going to replace the old BE Act of 2003, which was intended to promote black economic empowerment, and it turned out that there was a lot of abuse of the BE codes and the way BE should have been implemented. Companies were committing fraud in many cases, issuing misrepresentation on their own scorecard, in some cases fraudulently producing their own scorecard. In many cases, companies were appointing a black person to a board of directors when he wasn't a member of the board in the first place. We've seen situations where a company would sell shares to a black person, but at the same time they would have another document or a contract where they would buy the shares back from the same black person, which means that there was no real benefit that was flowing. As a result of that, the new BE Amendment Bill is going to outlaw or criminalise fronting, make it a criminal offence.
And you can get up to 10 years in jail or ultimately a fine of 10% of the company's turnover. So this is basically legislation to address the fact that in many cases it's undermining the ultimate objective of black economic empowerment in South Africa. But let's talk about the various guises of fronting right now. I mean, what is the most common form that you come across?
I think the most common form is where a company would sell shares to another person or another organisation, but that person or organisation would get no benefit. There'd be no economic benefit flowing through to that particular black organisation or black person. And without giving names, I've come across a company that says that it has a 66% black shareholder, and yet not one member of their board of directors is black. Which really is an indication of a problem. Maybe it's not fronting, but it sounds very much like it. Another indication or another instance of fronting is where companies will quite simply fraudulently produce their own certificate. They're supposed to use a verification agency, and I've seen situations where a company will use a verification agency's logo and put in their own numbers.
I mean,
change dates.
It's flat fraud. There's nothing else, that you can kind of disguise it as right now. But I'm sure there are going to be a lot of companies that are going to be taken to the court, and they potentially could be claiming ignorance when it comes to this. I mean, how would that potentially play out?
Yeah, that's a very interesting one. Obviously, they say ignorance of the law is no excuse. But in the case of this BE Amendment Bill, they specifically talk about they use the word knowing. That if you know that somebody misrepresented, or you're a company CEO and you know that you have misrepresented, or even worse or more important, you ought to have known that your company was misrepresenting their B score, then you are guilty of an offence. What this means is that a CEO and a board of directors, a social and ethics committee, needs to be very aware of their B certificate and their scorecard and their status.
And as you say, ought to have known is really the key clause there.
Yeah, they can't now use the excuse. I gave it to my PA or my verification agency and they advised me on this. You need to know, and for every CEO out there listening and viewing, he needs to know that he needs to look at his own B certificate. And we have come across simple situations where the certificate didn't add up properly, or more points were awarded than were available to be awarded. And when I spoke to the companies involved, they said, well, we didn't even know, we didn't even read our own B certificate. All I'm suggesting is that many CEOs read their own B certificate. They might not be deliberately fronting, but somebody else might be doing it on their behalf, and they are only too happy to accept this situation.
So whether it's deliberate or not, so whether it's undermining the overall objective of the law, means that you could be up for a criminal offence, and you could be held up for that. But to what extent is it going to be the case that those who are tested in the courts when it comes to this legislation ultimately will have to face the maximum penalties?
That, of course, I suppose, is for a judge and a court of law to decide.
I mean, how bad does the fronting have to be, to put it in plain and simple terms?
Well, I think it would have to be very bad to put somebody in jail for potentially 10 years. Many other crimes in this country are committed and people get off with a far lighter sentence. So in a way, a 10-year sentence is a really serious issue. I personally don't think, I'm not a judge or a lawyer, but I personally don't think that if somebody made a mistake on his B certificate, he deserves to go to jail for 10 years. At the worst, he deserves to maybe lose the business from his customer who received the certificate. But 10 years is a lot, and even as a B consultant, I'm very concerned because if I advise my client and I make a mistake, or my own staff make a mistake, we ourselves could have potentially 2 years in jail. So we're very aware, and I don't want to ever accept a certificate from somebody and advise my client to use it, or advise my client wrongly because I don't feel like going to jail today.
Yeah, absolutely. I don't think anyone, without intention there would want to do it. And that, as you say, has ramifications for the entire consultant industry, which has certainly become quite big in South Africa when it comes to advising on BE, status of a company right now. So take us through your thoughts in terms of the cost that this legislation is going to have for companies going forward, because that is, as you say, is going to have ramifications for service providers like yourself.
I'd like to think that there's going to be no cost to any company, or certainly no company that is doing it correctly. In fact, there's great benefits to most companies to receiving or to know that there is going to be penalties against some of the opposition who might be doing it wrongly. And I think that after the first 1 or 2 situations are discovered, many companies are going to take a look at what they're doing, take stock and decide not to engage in any fronting activities. For the vast majority of companies out there, I think they're going to be only too happy that they will be evaluated in terms of their B situation exactly the same as everybody else, as their own opposition, which means that it's going to be a far fairer situation. It's going to be a lot more consistent. Of course, there is another slight issue that needs to be maybe mentioned if there's time, and that is this amendment bill establishes an office of the BE Commissioner, which is a particular position probably to be filled by a judge or advocate whose job it is to investigate these fronting issues, which could take, I suppose, 6 months to a year before that office is filled and before the fronting is starting to be investigated. So I think...
So we're looking in terms of actual implementation of the legislation 6, 12, maybe a year down the line?
Yeah, sadly that is the case.